All right, Judge. Well, you asked for the meeting, so
Yes, well, thank you for being here. August 31st, 2016. I did ask for the meeting because you had asked me some questions about the Mike Tony's motion to recuse me. He then filed an affidavit of disqualification. I then filed an unsworn response. He filed a reply, and then I filed a sworn reply. Justice O'Connor has not ruled on it yet. The normal policy is that we don't comment while it's pending. However, there are extraordinary circumstances in which we are allowed to comment, and I think knowing that two other people have strayed from the no comment policy that we allegedly have here at the court is an extraordinary circumstance that will allow me to comment. So while we spoke off the record last time, I am here to answer on the record as much as I can. The one thing I will not do is lie. If I feel like I'm going to put somebody else in danger or cause a problem, I will just say no comment or I can't go there. The first statement I want to make is 2 years ago when I recused myself from Mike Fine's cases before he surrendered his license. I was kind of taken to task a little bit in an op-ed where my integrity was questioned. And I can understand why Andy Young did that. He did not know the full story. I certainly did not put the full story in there, although there was a lot of information. I didn't include everything. But of all the things to question, my integrity, ironically, is probably the one thing that can't be questioned. Certainly, if he wants to question my sanity, he can take a number and stay in the line because based upon this case, everybody's sanity is up for grabs. But my integrity as a judge and as a magistrate, I am all about due process and fairness and not making people look bad in front of their clients and not putting people in bad positions. When I was a detention home magistrate, I was the first magistrate to stop taking pleas of guilt, basically. They call it admissions in juvenile court, from juveniles who don't have attorneys. I stopped accepting waivers of attorneys because all of that was unfair. I stopped locking up kids because they were African American boys who maybe only had a single parent. I brought a lot of fairness into the system based upon things that I had seen. I don't need the law to tell me what's unfair. I don't need the legislature to tell me what's unfair. I know unfairness when I see it. Everything from restraining juveniles, which we stopped doing long before it became the norm. A lot of reforms we put into place. By we, I mean me and Steve Blake, my magistrate, who was my magistrate also at the detention home. And I brought that same thing into divorce cases. I don't favor one gender over the other. I favor facts and I favor law, but I try to be as fair as possible to the clients. I do what are called case management conferences, which is a hearing that is filed 6 weeks after the initial filing of a divorce. No other judge does that. I do that because people don't see a judge until the end of their case. They don't see a judge until there's a trial. They don't see a judge until there's an uncontested. 18 months into a case with children, if you're lucky, you see a judge. So I see them 6 weeks after they file, and I tell them very bluntly and very openly in front of their attorneys what they're in for, and how long, and how stressful, and how costly litigation is. So, I put a lot of things into place. Children's services cases, we automatically give attorneys. That is a change in format than everything that has ever happened before. So I am very sensitive to due process and fairness issues. Specifically, I have never taken out upon a lawyer upon a client even, something that a lawyer has done. And I have not done that because long before I was a lawyer, I was a litigant. And I was a normal person. And I was a member of the public who was involved in a custody case. And I remember the backslapping that went on with the judge and the lawyers. And I remember how we'd go to court for 30 days. We'd get a continuance. And we'd come to court and nothing would happen. And there'd be another continuance. And nothing would happen. And there would be another continuance. And we would just get bills and bills. And I specifically remember when I did some criminal defense work, how I was treated by two particular judges who did not like to work. They are deceased. And consequently, they punished my clients because my clients had the nerve to ask for a trial. And one judge was so brazen about it that he told Kara Ritter, who was a reporter for the Plain Dealer at the time, I think she's up at the Boston Globe now, he told her that he sent my woman to jail for 60 days because she had the nerve to fire Jack Bradley and hire me and ask for an attorney. And to me, there is no greater sin that a judge can do than to take something out on a member of the public because of something their lawyer has done, or because they have only asked for their rights to be enforced. They've only asked for a trial. So I learned what I would never do as a judge, and that's one of the things I would never do. Of all the things to question about me, integrity is not on the table. I am the only judge in this building who interviewed for my staff. I am the only judge in this building who did not hire my campaign staff. I am the only judge in this building. I am a Democrat who ran against a Democrat. And if it didn't take some integrity and strength to do that, then I don't know what it took. But when I won, I interviewed for those positions. And I asked each interviewee, would you like me to call you if I don't give you the job, or if you get the job, obviously you get a call. And I went so far as to call them when they didn't get the job, because most of them wanted a phone call. So as a Democrat, I hired 2 Republicans. Of the 6 people I could hire, 2 Republicans, a Libertarian who's an Iraqi war vet, and 3 Democrats. I tried to go for diversity, not because it's politically correct, not because it gets me points somewhere, but because I actually believe it.
What were the totality of circumstances?
Totality of circumstances were, as I listed in my affidavit to respond to his second response, I had made statements to law enforcement about Michael Fine and Michael Tony, and in particular one case that occurred here in my chambers. And subsequently probably spoke with the investigators, I don't even know, 5, 6, 7 times over the course of a few months. I never spoke with the prosecutors, never had substantive conversations with them. But I left there with the impression, certainly not the last time, but probably 3rd or 4th time I talked to them, that they would be investigating Mike Tony and one other attorney, actually, who I will not name because I don't know anything of that. But they were concerned about fees. And apparently there was some back and forth on the case that was in front of me, where he and Mr. Fine demanded large sums of fees from a particular client or threatened to get off the case. So that was part of it. The other part of it was I did not feel comfortable having him back here in my chambers. He had had a history because we had been friendly. I've known him for over 40 years. His youngest sister was my best friend in kindergarten, 1st grade. She died of a brain tumor. He's from South Lorraine, I'm from South Lorraine. Our families intermingled. I went to his mother's wake, went to his father's wake, he came to my brother's wake. So I was on somewhat friendly terms with him. But he used to use my office basically as his own office, the outer chambers. He would spread his documents out, and I would find out that it wasn't even for me. He didn't even have a settlement conference with me. He didn't have anything with me. And he had a history of doing that, having things faxed to him. And that came to a head the morning that Mike Fine's office was raided. We had heard that something had happened and it was bad, but we didn't know exactly what it was. I remember speaking with another judge and we assumed it was child porn, or something like that. But all we knew was that his place was raided. And it was right around that time that Mike Tony was standing outside right by my secretary's desk. And she said she had the feeling that he was there for her. My court reporter said she had the feeling he was there for her. And I said, well, that's funny. I thought he was waiting for me. And I said to him, Mike, what are you doing here? Is there something we can help you with? Because he's just standing literally at that table by my secretary. And he said, oh, it's nothing. And he started laughing. And later on, when he was by the fax machine, which usually my secretary uses, I asked, what is he waiting for? They said, well, something for Boros. And that's when I said to Dwayne, my bailiff, let's go have a talk with him. And I said, found him on the second floor. Terry Butler's office, it was his hearing room, excuse me, not his office. Dwayne and I just went in, I said, Mike, can I talk to you for a minute alone? So we closed the door. He says in his reply that he sat down and he felt he was being scolded. He never sat down. But to me, that's not a lie from Mike Tony. That's just somebody who who remembers it differently. I mean, that's just, I think he was a little shook up and he thinks he was sitting down. He never sat down. He stood by the door the whole time. It took less than 5 minutes. And that's when I told him, Mike, I don't want you using my office as your personal office anymore. I don't want you coming back into my chambers alone. And if we have settlement conferences, I'm going to do them on the record.
Are settlement conferences normally done on the record?
They're normally done on the record if the attorneys ask you. Like I'd say probably 60% of my settlement conferences now are done actually in the courtroom. And most of those are done on the record. But usually they're done off the record in chambers. So that would have been how he would have been treated differently.
Okay. Could a lawyer who is treated differently feel they are being singled out?
They could, absolutely. And he could have felt that, well, what's going on? And that is what I think led to all of his frantic phone calls that occurred in the next 24 to 36 hours. He called my magistrate 6 times on his personal cell phone. He called everybody he could possibly call, and I was not going to have any more communications with him.
Well, you wrote in your one of your filings that during that conversation, which took place on November 24th, 2014, correct?
Oh, that's what he said. I took that from his affidavit, November 24th.
Okay. I thought you had said, but in any case.
I did say that, but I was quoting his affidavit.
Okay. You said that his reaction was he appeared frightened and then said, what's wrong? What did I do? What am I being charged with? Am I being arrested?
Yeah, he was...
Did he say that?
Yeah, he was stunned. And I tried to reassure him. I said, Mike, you're not being charged with anything. I'm not charging with anything. I said, I just don't want you back in my office anymore, using my office as your personal office. That's all.
Okay.
But he did say, his reaction was out of left field. I mean, it was, what am I being charged with? What are you accusing me of?
Well, he says he asked, what did he do wrong?
He did ask that. He asked 4 or 5 questions in a row. I mean, they were just, what am I being charged with? What did I do wrong? And he may indeed have not said, am I being arrested? I think the thing was, am I being charged with something? So, again, this is 2 years after it happened, almost 2 years.
So this was about a year into your term?
It was about 2 years. I would say about a year and a half. It was probably in mid-14, I think.
All right. had he had a lot of cases in your?
No,
So
No.
is it possible you just didn't remember him?
no.
Okay.
He was quite insistent that I knew him and knew him well.
Do you
And the
re-
reason I say that is because of this. Here I go again, put myself out there. Judges are not supposed to refer anybody to attorneys, or attorneys to anybody. However, if another judge asks you, as a professional courtesy, sometimes we'll say what we think. And somebody had asked me before that, another judge, well, what do you know about Mike Fine? I said, he's a good attorney. I said, I think he settles when he can settle. He fights when he has to fight. I think he'll be fine. And in fact, by this time he was working for Jamelis and Illner, and I said, I think that's a good pickup for Jamelis and Illner. It's like the Browns getting Ben Roethlisberger. And then I started laughing. I said, maybe that's not the best comparison. So that occurred before the incident in my court reporter's room.
Okay. But judges certainly talk about lawyers. You guys have
Yes.
meetings. I assume you have an opinion on most lawyers that you may have, that whether you share with them, but I
Right.
assume judges say, oh, so and so's a good attorney, so and so's not so good, so and so's stubborn, or whatever the
Yeah,
opinion might
they
be.
get emotionally involved with their
They-
clients,
they-
or they're gonna run their
Right.
retainer up, or
Right.
that kind of thing.
So is saying that Michael Fine was a good attorney and just describing him the way he just did, that he settles when he has to settle, that he fights when he has to fight, is that out of character for you to describe an attorney or make a frank assessment to another judge about an attorney's capabilities?
I hadn't been asked a lot about other attorneys. But the ironic thing was that particular judge asked me 2 more times. And I used the same exact language. He's a good attorney. He settles when he can settle, he fights when he can fight. He's, it's a good pickup for Jamelis and Illner. It's like Ben Roethlisberger. And that other judge was trying to tell me that his client was having, or that his friend was having issues. Only that judge was not open enough to tell me about the issues. Later on, that judge would say that his friend experienced some touchy-feely moments with Mr. Fine. And I said, I don't know anything about that. And then came the famous, when they left here on a different settlement conference, he stopped right there after the other attorney had left, and he said, Judge, I hope that we can talk sometime, just the 2 of us. Can we be alone, just the 2 of us? It has nothing to do with the case in front of you. I just want to talk to you, alone.
And you had written about that in your affidavit, correct?
Yes?
Or your recusal from,
Yeah, Mike Fine's cases.
and what did you do? Did you have a private
I
meeting
said,
with him?
no, I said, go ahead, and I said, hey, set it up with my secretary. And that incident occurred right around the time as when he first told me that he was conversant with hypnosis. So that's what started that whole thing. It was when he sat in the outer chambers and was staring at the bookcase and said, Judge, I believe everything you ever said about what happened in law school, which was bizarre in and of itself that he would bring it up. But I said, really, why? Wow, I watched Dr. McPherson drop a kid into a trance in 5 minutes. I said, Dr. Sandra McPherson? He said, yes. I said, I didn't even know she did that.
Okay.
And so it was later, during that same time, that particular incident is when he's asked to be alone. That also contributed to my desire to not want Mike Tony back here in chambers alone.
So you believed at the time that Michael Tony was either in league with Mike Fine, or was aware of what he was doing, or had used him in some way, shape, or form to?
I can tell you what I thought at the time, and then I can tell you what I found out later. Was that when Mike Tony would have cases, he would get Mike Fine to co-counsel allegedly. What I knew at the time was not that, however. What I knew at the time was that he had co-counseled on a case in which did not require co-counsel. That he had acted strange when I told him that whole thing about, I don't want you back here. That he continued to act strange for another 24 to 36 hours, where he was just literally demanding that I call him back and communicate with him. And what I know is that Mike, Tony and I had a very long conversation in this office. When he asked if he could come see me, he said it wasn't about a case.
This is Mike Tony or Mike Fine?
Tony sits in the left-hand chair and starts talking, this long conversation, long monologue actually, about his secretary's sick cat. Because everybody knows I'm an animal person. So his viewpoint, according to his response, was that he was just trying to get some advice about what to do about his secretary's sick cat.
Okay. My
My viewpoint was that it was a very long, confusing monologue that was almost incomprehensible, to the point where I did not put in my affidavit my full response to him. But my full response was, Mike, what the F do you want from me? I don't understand what we're talking about. I don't understand what you're doing. I don't understand what you want from me. Do you want me to tell you you're a good boss because you let your secretary bring her sick cat in? I don't know what you want. Do you want me to tell you to fire your secretary? And I got so frustrated. I did not feel comfortable having Mr. Tony.
Okay, so is there then, I get, all right, so those are the totality of circumstances.
Yeah, and I did not want to put them out in public.
Okay.
I did not want to accuse Mike Tony of something that I didn't know was happening. I mean, all I knew was that he co-counseled, and I knew that there were some weird situations that happened. But that could have amounted to nothing. It could have meant nothing. And so I didn't want to put that stuff out in public. And so when he asked me to recuse myself, I did.
Okay. And continued to do so for roughly a little over 2 years?
Yeah, we would still check
A
him.
year and a half?
Yeah, when he did motions to transfer, we'd check, as long as it wasn't set for trial. Like, a lot of times, he was initiating cases, so that was easy, and those cases got transferred. In the beginning, Judge Boros gave me regular cases. Judge Janik's policy was somewhat different in that he left it up to his magistrate to decide which cases to transfer to me. I got all the high conflict, difficult cases, some of which are still ongoing. One is going on for 5 years because of the attorneys. So we looked at them case by case. And in the beginning, there was a mass transfer. That was his initial request. That was my way of saying, okay, listen, something is wrong with you right now because of his behavior after that conversation. And I don't want to be around you, and I'm afraid that I may be something, I may have been influenced, and I am not going to put the public or the litigants who appear in front of me at the mercy of me trying to figure out if he had done something. So I recused myself. It was the easiest thing to do at that time, and I think it was the best thing to do.
Okay.
Then, as time went on, we looked at them more and more. There were some problems initially. As I said, I got a lot of high conflict cases. That is a common thing that judges do. They'll get rid of their bad cases, what are termed bad cases. Judge Boros did not do that, but so time went on. We started noticing he would be appearing right before trial. Something would have been done in my court for a long time. We had handled it for over a year. It was already set for trial, and then all of a sudden I get a notice of appearance.
Does that happen commonly before trial?
It started happening recently.
Do other lawyers do it, or just Mike Tony?
I am sure other lawyers do it. People get fired. but not with this consistency. You've got a case where it's going to trial, long set for trial, and he appears 1 week before trial.
That's the case
woman
that's the case at bar here?
Woman gets off this is the thing that started my refusal to recuse myself. There was a case, 2 cases after the child support case, where he wanted off of a child support case that was going to be heard by a child support magistrate who works for all 3 of us. That makes no sense. If I had to start recusing myself from those cases and then start getting cases in return from the other judges, that was really going to be a mess. So I said no to that. And I said, you can reconsider. And he filed a motion to reconsider. I said, motion to reconsider is granted. A reconsider is denied. You know, I'm not recusing myself from a child support case where the child support magistrate works for all of us. Then there was this case, and it was set for trial. I'm the administrative judge, so it got transferred to Judge Boros. Judge Boros came down here, pretty livid, sat in the chair in which you're sitting. I said, Lisa, you know there's forum shopping going on here. And I said, yeah, Debbie, we knew that was going to be a problem when this started. She told me that the case hadn't been set for trial and it was almost overdue. I had my secretary look it up. It had been set for trial. And then somehow the trial was continued. There was no order from Judge Boros or myself that allowed that trial to be continued. Somehow the trial was continued. My guess is the assignment commissioners just took Mike Tony at his word and said it's being transferred, let's continue it. So, by the way, this incident was in early June, I think. He filed a motion to get on the case, I think June 15th. But we had already had discussions in the judges' meetings about forum shopping.
All right,
And about the problem this had become.
I talked to both Judge Boros and Judge Janik.
Right.
Both of them don't really recall it in exactly the same way. Judge Boros said she did recall you being concerned about it, but...
Do you think I would have been concerned about it after 2 years? Or is it more likely that my 2 judges were unhappy with trading cases back and forth?
I don't know. I just know what the other judges told me, that she hadn't, Judge Boros told me she hadn't discussed the issue of towing with you or forum shopping with you.
She misremembered.
But you knew, all right, and Judge Janik said that wasn't an issue for him, and he said, and I quote, I have not had or expressed concerns about forum shopping or the effects of that on any court's docket.
Jody Barilla is our court administrator. She sits in our judges' meetings. She will tell you, in at least 3 or 4 judges' meetings, prior to this early June incident, we had discussed the problem about how I get Mike Tony's cases back. And I was frustrated. And I said, tell me, to the other judges, what do you want me to do? Do you want me to not recuse myself and have him file an affidavit, and then we're going to go through all this rigmarole, and all of this stuff is going to be made public, and it's going to hurt him, and it's going to hurt me, and it's going to hurt the bench. If you want me to do that, I'll do that. And I said, what do you want? How can I get these cases back? You tell me how I can get them back, and I'll do it. And then we finally figured out after this time that the next time he filed a motion to recuse, I would not recuse. I would not recuse myself.
So the 3 judges came up with this plan?
No. I came up with this plan after talking about forum shopping with the judges. Contrary to what they remember, I can assure you that my secretary remembers Judge Boros coming down here pretty livid. And that the first words out of her mouth were, Lisa, you know there's forum shopping going on. And my response was kind of like dumbfounded. Like, of course there's forum shopping going on. We knew that was all going to be, we all knew it was going to be a problem when it happened. And then we went on to talk about other things. So it's possible that she doesn't remember that. I tried to refresh her memory yesterday, and she did not want it refreshed.
She didn't talk to you, or she did not?
Yeah, she just said it didn't, she doesn't remember it that way. I said, well, why don't you let me give you the context?
But if you believe that he at least had knowledge of it,
Right.
if you believe he's done something improper to you, or with you, in terms of the meeting, or
Right.
you've told him he's going to be treated differently than other attorneys, and he says, well, I feel like she could treat me unfairly, or treat me differently, or treat my clients unfairly or differently.
Right.
Could a reasonable person make an assumption of a judge who has basically said that she suspects him of being involved in criminal activity, that she suspects him of being, that she believes he's done improper things in her courtroom, and that she plans to treat differently? Because I assume that I think you said the status conferences would remain on the record.
Settlement conferences would
settlement
not
conferences
remain on the record, they'd just be in the courtroom.
Okay, so, all right.
So without the court order.
Okay. Could a reasonable person say, she thinks I'm a criminal, or at least involved in some sort of criminal activity, and thinks I've done improper things? Could a reasonable person say, well, she can't be fair to me?
Absolutely, a reasonable person could.
Okay. So if a reasonable person could make that inference, could then there not be the appearance of impropriety in your
Absolutely.
continuing to hear cases?
Yes, there could be the appearance, and yet the canons and the advisory opinions are, if you even are a witness in a criminal case, and here's the reason, I'll give you the reason why. If I see Mike Tony punch Mike Fine in the nose, and I'm a witness to that, am I now required to recuse myself from every Mike Tony case? And if that were the case, then if you really want to forum shop, you would just make an accusation against the client, or make a threat, excuse me, not against the client, against the judge. And the judge, somebody made a threat against me, I went and got a CCW, now I have to recuse myself from their cases. Ironically, the ethics opinions are that you do not necessarily have to recuse yourself, even if you are a witness.
But
And I'm not even a witness.
But the
as far as I know.
ethics rules are that if there is impropriety, or the appearance of impropriety, you are supposed to recuse yourself,
Right.
correct? And you just said
You should recuse
You
yourself.
should recuse
Yeah.
yourself. So, and you just said that a reasonable person could, based on your history and with Michael Tony, could make the inference or belief that you could treat him unfairly.
Right.
So if there is that appearance, if it is possible that a reasonable person could make that leap to there is impropriety, why would you go back and say, well, now I can hear his cases? If people could look at it and say,
Right.
she can't be fair to him.
Well, because the standard isn't if people could look at it. If that were the standard, most counties where there's only one judge and a bunch of lawyers, they would have to recuse themselves from everything. The standard isn't the standard that necessarily I applied 2 years ago. That said, if people looked at this later on and said, why did you sit on that stuff? Why did you sit on his cases? She couldn't be fair. But that's not the standard. The standard is if there's an appearance of impropriety. And if I remedy those situations, and the settlement conferences are not on the record, but they're just in the courtroom, as I do many of them now, he's not being treated differently. And again, I don't have any clue about the nature of an investigation against him, if it's ongoing, if it's going to happen, if it's done and they decided not to do. I have no idea. So I'm just going to treat him as the Mike Tony that I knew. I just don't want him back here.
Are there any other lawyers that aren't allowed back here?
No lawyers are allowed back here.
In your chambers or in
In my chambers.
And that would be this room?
That's this room. The outer chambers, yes. The attorneys have to be buzzed back, and where Dwayne goes to get them.
Okay.
So. And that's another thing that he misunderstands. That may not have been the policy when I first started. I had an open door policy. Come on in, get coffee, get whatever. I have pizza every Monday at 11 o'clock for employees. So it was a very open door policy. That policy ended with Mike Fine.
Okay. All right. One thing I wanted to ask you about was you were not one of the victims who is going to be part of. You were not being called as a witness in the Michael Fine case, correct?
No, not that I know of. I
And
mean,
you-
I think they've put together their witness list, and I can't imagine being called on anything at all, other than maybe rebuttal, if he denied that he told me that he was conversant in hypnosis and about the Dr. McPherson thing.
Okay. There's a mention in your thing there that Michael Tony is on Michael Fine's defense witness list.
Yes.
How do you know that? I couldn't find it anywhere in the file.
I can't either. I was told that anonymously, that the two people were maybe a prostate surgeon, Mike Tony. And I had a tendency to believe that because I was also told that Mike Tony was at Mike Fine's last pretrial, not this final pretrial, but the one before that. So to me, it was like, okay, well, that makes sense. He must be calling him for some reason. And I don't know. Don't have a clue.
Okay. So, do you think that this is something, do you regret trying to go back on this?
I regret it now, since apparently my two colleagues feel that there's no problem with forum shopping, and that they never had a problem with it. Otherwise, I could have just stayed off his cases.
Why, I mean, I guess, if you knew this was a possibility, and if you had wanted to avoid embarrassing the bar and the bench and the
Right.
justice system, which, as you noted, has had quite a few body blows in
Right.
the past few years, why take the risk? Why gamble with the public's faith?
Oh, the fact that they may think that one of their judges was unethically influenced, why gamble with that? What choice did I have once he filed the affidavit? The choice that I had was before he filed and to recuse myself. But it was becoming obvious that women were hiring him and men were hiring him to delay cases. And that became obvious with the Porter case, if I had any doubts about it beforehand. So that is a fraud upon the court, if you ask me. Once he filed it, what was my option? My option to the Supreme Court was to lie by omission and to just say, no, I just asked him not to come back here into my chambers. So I could lie by omission and not say, oh, by the way, there's this other problem. Which, as you know, I'm not one for lying. It's too much trouble. You gotta think of a lie, you gotta have a backup lie, you gotta remember your lie. It's just, I would rather tell the truth and let the chips fall where they may. And the chips have fallen all over me. Do I regret it? I regret that he filed the affidavit and that we didn't have the conversation.
How had you told him that you would be willing to have that conversation? Through your bailiff?
We had a hearing on that case, and he was not going to appear. And Mr. Anderson told him that, well, I was going to go forward with the hearing, just to make sure that it didn't meet one of the three requirements, the three exceptions that allow a judge to make orders even if there's an affidavit of disqualification. He did show up, and he brought an attorney with him, who said he was just there to hold his hand, Jim Barillo. And I basically said, you know, I don't know if you can withdraw this, Mr. Tony. I don't know what the mechanisms are. I don't know if it exists. But perhaps if you wanted to research it and see if there was a way to withdraw it, we can do the reconsideration motion, and none of this would have to be public. And he has a transcript of that hearing. And then when he said, well, Your Honor, I'd be willing to withdraw it if you continue to recuse yourself. And I said, I don't intend to do that. I intend to sit on your cases.
But in and of itself, didn't that? I mean, if you told him you should file a motion to reconsider, and he said, well, you know, this is what I want, which was you not sit on my case. You said, well, that's not going to happen. Did you really leave him with any? I mean, if you already told him what the outcome was going to be, why go through filing the case?
Because I think what he wanted to know was what had happened 2 years ago. I think he never had those answers from 2 years ago. He had tried everybody. He had tried the administrative judge. He had tried John Haynes, and I wouldn't discuss it. I wouldn't discuss it with anybody. I would just say, you know, he asked me to recuse myself, so I recused myself. But he would have gotten the answers that he wanted, and it would have been between us, my bailiff, and anybody else that he chose to have present. And then I would have said, listen, it's been 2 years, and I don't know what's happening with you, but you know, he knows me well enough to know that I would never have taken anything out on his clients. But, you know, I can understand why he would file that. I just wish that he had not. And I certainly regret it now that I know that my two fellow judges deny that they had conversations with me and Jody Barilla about forum shopping. They certainly never pushed me to not do it, but when I said to them, well, what do you want me to do about it? Okay, the next time he files a motion to recuse, I won't recuse. I'll let him, and then I didn't think he'd file the affidavit of disqualification because of this stuff, and he filed it.
Did you talk to both of your fellow judges yesterday about their conversations with me?
I did talk to Judge Boros yesterday, and then I had not heard from Judge Janik, but there had been a no comment policy here, and especially when there's a disqualification, because the point is, I technically should not comment until the Supreme Court justice rules. So why would you put a fellow judge in that position where you're commenting, and it makes it look like she's either inaccurate or lying, but she can't comment until the Supreme Court justice rules. So when I asked Judge Janik if he had I said, did you deviate from our no comment policy too, or did you talk off the record? And we got an answer that said we'll talk tomorrow. That was all the answer I needed. So, do I expect now that I would probably be kicked off the case? Probably. I'll be
Kicked off Tony's cases?
Tony's cases. After speaking with you. Even though I don't think there's a good reason for it to have happened. I think now that I have commented, do I think that people will question my sanity? Sure. Do I think that it will impact me if I seek re-election? Sure.
Why would you think people would question your sanity?
Because of this hypnosis stuff. People have such misconceptions about it. Until and unless you actually see it in person, either on a cruise ship where it's an entertainer doing it, you don't really understand the concepts. And so, you know. And let's face it, Brad, you've been a reporter a while. I've been a magistrate and a judge, and where nobody would have put that stuff in there. They would have just lied by omission. They would have just said, I asked him not to come back here. He wanted those answers 2 years ago. He has them now. Everybody has them. "20 years after I first faced this issue, I never thought I'd have to deal with it again. It's come back. Right here in my chambers.
Anything else you wanted to say?
No. Other than, I feel bad about the whole thing. I feel bad for Mr. Tony. I feel bad for myself, for the bunch, for the bar. I feel bad for Mike Fine's victims. I feel bad for anybody who thinks I'm doing a good job, because chances are pretty good I'm not playing again. All I can think of is that stupid line from Casablanca. Of all the gin joints and all the places in the world where somebody could have walked in, of all the places Mike Fine would have come in. What I don't feel bad for? I don't feel bad for my two fellow judges that we're going to continue to have to case share. And Mr. Tony, I wish him the best of luck.